Well, I guess we're ready to get started. Last program of the day. So I know that you're on your second day, and you've heard a lot of ideas, and so it's always a challenge to be the last people up. So we'll try to make it interesting, and our job, I think, in some ways, is to somewhat debrief on and talk about where's the future. And where are we going? What are we doing? Are ideas converging or diverging? And I think this is a good opportunity to, after you've heard a day and a half, to take stock. And I have three excellent panelists. I have Mike Rappaport from UC San Diego, Sai Prakash from University of Virginia, Barry Friedman from NYU. And I think I am the only, with the exception of our organizer here, I think I am the only judge in the room. And so that puts me in a little bit of a different perspective. And probably any of you that, as you know about judging, we can't comment on pending matters, but you're all talking about things that I know something about, or I've heard something about, or maybe written in the areas. And I was struck by the last comment that judges need a lot of help. And so I couldn't help but, going back to my litigation days, to say that maybe academics need a little bit of help in understanding what judges do. And so I thought that I would take that point of privilege. But I think in setting the stage and moderating this, I realized that moderating a panel of academics is not unlike sitting on the Ninth Circuit in terms of trying to persuade people of your particular view. And I want to say that, I talk about judges as herding cats. I think academics may be even a little more difficult. So in terms of preparing for this, my panelists haven't told me everything that they're going to say. So I didn't tell them, payback is a bleep. I didn't tell them everything that I'm going to say either. So as far as that goes, I think that they have some interesting views, and then hopefully we'll have a little bit of, I want you to be thinking as you're listening too, as they stake out their positions, maybe after you've been here a day and a half. We'll take a poll and say, are you in Team Rappaport, Team Prakash, or Team Friedman? And so that as we can proceed, because I think part of the debate about where we're going, what's the future, and what you're doing, I know that you all do what you do with great purpose, but what is the purpose? And if we have, who are you trying to convince, and who are you trying to affect, and what is the outcome? So I think we really have to, we have to think about that in terms of the discussion. But no judges and no academics were hurt in the preparation of this program. So I want to let you know that. But I am taken by the fact, I just came here today, so I only have a day of experience of how certain everyone is in their particular views. And I have colleagues that are that certain, but if everyone is that certain, is there, in our job, we have to come up with an answer and what's right. So how can everyone be right, but everyone is still so certain? So is there any place for compromise, and maybe even thinking in terms of, is anything that you've heard from your colleagues, has anything affected how you think about your particular job, or how you think about your particular views? Are we affecting each other? And so where is the history? So in terms of, we did have emails and conference calls. One of my panelists missed one of the conference calls. So you can guess when I tell you who's going first, who might have been the person that missed one of the calls. And so, and I brought with me something that I use in judging frequently. It's my crystal ball. So I'm going to pass that down to Mike to start, and then he can pass it down to Sai, and then down to Barry to tell us where we're going, where the future is, and then I'll check it at the end and I'll tell you who's right. Mike?
If you'll excuse me for a second.
It's a lot like originalism.
I guess we shouldn't pass it. Well, thanks. So the subject of this panel is the future of history and constitutional law, and I want to restrict myself largely to the future of the role of history within originalism, the area of law that I know best. Of course, it's difficult to predict the future, right? So I wouldn't want to do that too much. So I'm going to make a key assumption here, and I'm going to assume, not predict, assume that originalism will continue to grow at the pace it has in the last decade or two. And if originalism continues to grow, then what will history's role be within originalism? Okay? So first, what I want to do is describe the role of history within originalism generally, something we talked a little bit about this weekend, but that's what happens when you speak last. Then discuss how history functions within two particular theories of originalism, original methods originalism and the new originalism, and then conclude by discussing the possibility of greater cooperation between historians and originalists. So let me then start with a discussion of how history functions within originalism generally. So originalism is concerned with a particular type of history, in my view. So first of all, of course, originalism is focused on history at the time of the enactment of a constitutional provision. Although, of course, the history before and after the enactment may be relevant to the meaning, but what we're really interested in is at the time of the enactment. And second, originalists are not concerned with history generally, but only with history that'll inform the original meaning of a constitutional provision. And I think the narrow focus here is key. Historians are often concerned with much broader questions, causes of provision, effects of provision, such as whether the effect of the Constitution was to promote democratization. Originalists, by contrast, are focused on a narrower question of what is the meaning of a provision, and in the main, modern originalism answers the question by looking at materials such as word meanings and matters that relate, that inform such meanings. And this is important, I think, because it would be extremely difficult for originalists to do their job if it required the full expertise of historians. As we've heard this weekend, historians will tell originalists that they don't know that much about history. And to a certain extent, that's true. It's a narrow focus that originalists have. Not too narrow focus, but a narrow focus. All right, so let me move from originalism generally to two particular versions of originalism and the differing uses of history that they make. So the first version is original methods originalism, developed by John McGinnis and myself. And so this theory holds that in determining the original meaning of a provision, one should apply the interpretive rules that would have been deemed applicable to a constitution at the time. Yeah. So the main idea here is that the Constitution would have been originally understood using these interpretive rules, and therefore we need to apply these interpretive rules in order to determine the meaning. Original methods thus has an additional role for history over other originalist approaches, right? So while other approaches are concerned with historical meanings of provisions, original methods is also concerned with discovering the original interpretive rules. And this generates a large research program for originalism, for original methods originalism. But this historical research is once again in a narrow area of legal history, discerning the rules that interpreters apply to written documents like constitutions. Now, there's been some work done on these matters over the years, but much more work needs to be done. Now, in establishing these original interpretive rules, it's not just history that's relevant. As is often the case with originalism, one must employ a theoretical framework in order to interpret these matters. So, for example, how prevalent must an interpretive rule be in order to be deemed applicable to the Constitution? Must it be majority? Must it have been the majority rule? Or will a plurality rule be enough? A second originalist theory which has had significant influence, is that of the new originalism, associated with Keith Whittington and Larry Solom and Randy Barnett. And while this theory comes in both original public meaning and original intent versions, its distinctive contribution is that it believes there will be situations when vagueness or ambiguity leads the original meaning of the Constitution to run out. So, for example, while the term search in the Fourth Amendment might have a general meaning, how it applied in specific situations might be unclear. And in these circumstances, the new originalists will generally believe that interpreters must consider extra constitutional considerations under a theory of construction to decide cases. So what is the role of history under the new originalism? It's a bit complicated, I think. On the one hand, one might conclude that it requires less use of history. Right? So first, many new originalists tend to be skeptical of the original interpretive methods, and therefore they might not regard that as especially relevant or worthy historical inquiry. And second, if some of the time the original meaning runs out, then presumably the history relevant to determining the meaning of a term might seem to be less relevant if the original meaning runs out. On the other hand, in order to determine whether the original meaning of the term does run out, one has to know the meaning of the term. Right? So, thus one might argue that the new originalists require the same degree of knowledge of the history as other approaches do in order to determine whether the original meaning runs out. Well, when the original meaning does run out, how do new originalists decide cases? And do they rely on history? And the answer there depends on the type of theory of construction that the new originalist holds. Right? So one new originalist might believe that the answers not resolved by the original meaning should be resolved through early practice, in which case early subsequent history is going to be relevant. A second new originalist might believe that answers should be found both in early and later practice, in which case history is going to have a wider focus. And then a third new originalist might believe that the matter should be decided based on normative political theory, in which case history might not be relevant at all. So it all depends. A final issue concerning the new originalism is the type of history of word meanings. So many new originalists, such as Larry Solem, argue that the Constitution tends to speak in terms of ordinary language, and therefore, when we're looking at history, we ought to be looking towards ordinary meanings. By contrast, I believe that the Constitution often uses legal language and legal meanings, and therefore my focus will often be looking much more at legal sources. So there's going to be a difference there. Okay, so another question about the future of history turns on the relationship between historians and originalist law professors. And in my view, and we've certainly seen it this weekend, there's a great deal of conflict and misunderstanding between these groups. Right? If the relationship were to improve, then we could really hope for the possibility of a rich and productive collaboration. Right? One sign of progress would be if there was more joint authorship between historians and law professors. Right? So this is how things work in other fields, right? You have law professors and political scientists, and law professors and economists, and they both have distinctive contributions, and they work together. And but it does not seem especially common in this area. As original scholarship, it's hard to think of too many examples, if any. So this is a big topic, and I'm sure that historians have legitimate complaints against originalist law professors, but as an originalist law professor, maybe the most useful task for me is to respond to a few common complaints from historians, kind of as a first step at the end of the program towards starting a dialogue, maybe for the next conference. So one complaint against originalists is that they engage in law office history, and that means different things at different times, but which is ordinarily meant to be a biased portrayal of the history. And some law, you actually look and see, in some law office history that they point to exists in briefs submitted to courts. But we should hardly be surprised that legal briefs are going to be biased, right? They're legal advocates. The bias is an assumption of the system and is addressed through the adversary process. So I think the real question is whether academic originalists engage in law office history. Now, all serious originalists I know believe that such bias is improper. Right? And they recognize that if they exhibit it, someone can call them on it, and they're going to harm their reputation. So there's a real incentive not to do that. Now, of course, scholars may overread the evidence to support their argument, but that's certainly true of what historians can do as well. Well, a second complaint made against originalists is that they often ignore contending meanings that existed at the time. So if there were several different views, then how can an originalist conclude that only one of them is the correct view? Right? But one meaning can be the correct one, even though there were several different contending meanings at the time. For example, there were different views of executive power that existed prior to the Constitutional Convention, but through compromise and dispute, one view on executive power could win on some issues, whereas another view could win on other issues. Thus, advocates of a senatorial check on executive power could win on the treaty power, whereas advocates of a unilateral executive power could win on the foreign affairs power, even though in both cases others disagreed. Under originalism, the question is which view prevailed, and under most originalist approaches, one looks to the constitutional language in context to determine which of the views prevailed. Thus, I'm convinced by the arguments of Sai Prakash and Mike Ramsey, wherever he is, in favor of the Hamiltonian view of the executive foreign affairs power, not because that was the only view at the time, but I think because that's the best reading of the text. The other views just have much more serious problems. Okay, well, I know that historians have responses to some of these points, but I certainly hope that some kind of common ground can be reached so that we can allow for a greater collaboration. Thank you.
Sai?
Oh, yeah.
Pass it to Sai.
Actually, I think Barry's going next.
So, true. So I'm really glad to be here as well. I want to thank Michael and Judd and the center. It's been terrific. I mean, I told Michael before we started, it's been more terrific than I would have imagined. I have spent enough time in the Academy to think that some of these debates have a very familiar feel to them, and yet I've learned a great deal, and I knew a bunch of people that were here when I came, but a bunch I didn't know, and I've really enjoyed getting to know you. Sai, I've emailed with and never met in the flesh, so it's just been great to do that. The crystal ball seems apt here because when we all got on the phone, we agreed that it was a very weird assignment we had. None of us had a crystal ball. We didn't know that somebody actually had a crystal ball. That scares me a little bit. But actually, Sai announced he had a crystal ball, so I'm going to pass it to him for now, though I'm going to keep the floor, and he's going to tell us about the future. But when I thought about the assignment for the panel, I confess that I was struck less crystal ball and more Dickens, in the sense that we've had panels on the history of the use of history and Reconstruction history, so that would be the ghost of history past. We've had panels on liquidation and examples, so that would be the ghost of history present. And you know what that makes us. We are the ghost of the history of the future, or the ghost, as Dickens would have said, of the history of yet to be. And to set the room, I mean, you all remember the ghost. It's a spectral figure in black with a long finger. And here I actually have Dickens here. I wasn't WhatsApping Will Baud here on my phone. I was just bringing up my Dickens. So I'm going to read this to you. The ghost, you know, that's history, and Scrooge, that's us. So this fits pretty well. The ghost slowly, gravely, silently approached. When it came near him, Scrooge bent down upon his knee. From the very air through which this spirit moved, it seemed to scatter gloom and mystery. It was shrouded in a deep black garment, which concealed its head, its face, its form, and left nothing of its visible save one outstretched hand. It thrilled him with a vague, uncertain horror to know that behind the dusky shroud there were ghostly eyes intently fixed upon him, while he, though he stretched his own to the utmost, could see nothing but a spectral hand and one great heap of black. There's history. So we know how this goes. We've got the finger. The ghost of history future doesn't speak. It just points to things. So here's what it points to. Over here, we have a medieval group of people. By the way, I should warn you, I'm about to be the bummer of the conference. So over here, we've got a medieval group of people having what might be, if you'll forgive mixing metaphors, a Talmudic discussion arguing about meaning, both semantic and accepted, examining philosophical questions of intention and knowability, lost in linguistics and hermeneutics, grasping for that ephemeral thing, meaning. And over there, we have a group that's somewhat less ancient, but not too much, alchemists, frantically trying to invent some alternative to what the other folks are doing, muttering under their breath anxious expressions about legitimacy. And a third group, dressed all in black robes, struggling to resolve cases, real cases, talking in reverent hushes about precedent and about ratification, practice post and afterward, about evolving standards of decency and norms and traditions and history of the people, and almost completely oblivious to the other two groups. And finally, alone in a dark corner, an old, worn, and much tortured document, the Constitution, protesting with its last breath that if and only if it were handled much more gently and thoughtfully, it would give up its meaning. And so we, like Scrooge, wake up and think, does it have to be this way? And I'd like to think not. I'd like to think that we could wake up to find a shiny, not Christmas, but Constitution Day. And so let's I may be pushing the metaphor a little far now. So let's think about what the alternative might be. So we know what the problem is, right? It's obvious. We have a really old Constitution, and I'm suspicious that if we had one that wasn't quite so old, our discussions would be entirely different. But it is old, and it's difficult to deal with such an old Constitution, and so we struggle. I'd like to believe, though, and somewhat in the line with Mike on the other end there, that we could struggle together. Now, not agree, that's not my word at all. My word quite deliberately is struggle, that we could struggle together. And I say that quite deliberately because I think it's through that kind of struggle, through contestation and struggle and disagreement, that constitutional meaning itself is formed. But it's the kind of contestation that matters, and that's what I want to say something about. So, to be honest, I think we've gotten completely lost. We've gotten lost in some arcane debate about interpretive methodology, about how we should read the Constitution. And frankly, to be honest, I almost said this at the mic at an earlier point in the conference, but thought I'd say it now. I've lost track of what the fight is about. I mean, I once knew what it was about. I understood what was going on when people struggled about interpretive methodology in the 1960s and 1970s and even into the 1980s. It was about substance. I mean, we all knew that we were fighting about what the Constitution should mean, what it should say. And there were two sides to that. There was originalism and living constitutionalism. And though perhaps neither of them was very likely to succeed or do us much good, at least we knew where we stood and what we were for. But now, interpretive debate has taken over. It's become hegemonic to the point where I've completely lost sight of what the normative fight itself is about. Some people might think that's good, but for me, colloquially, I think it's too damn bad. I think we've abandoned our natural comparative advantage. I don't think we're linguists, and I don't think we're philosophers. I think we are lawyers, good normative lawyers, interpreting lawyers, and I think that being good interpreting lawyers allows us to fulfill an altogether important and essential social role. In short, I would say, quoting the title of a piece I wrote with Sarah Salo, who's currently clerking on the court, we spend far too much of our time talking about how to talk about the Constitution and far too little of our time just talking about the Constitution. And as a result, we've become isolated from one another. We've become almost irrelevant to adjudicators, people who are deciding what the meaning of the Constitution is, and I don't just mean judges. Lots of actors in society are deciding what the Constitution means. And so I wish we would return to that sort of normative, overt exercise of talking about what it is that the Constitution means. How do we do that? I just want to say two words, and then I'm done. First, I think in part we can do it in the language of judges. I mean, judges, despite all of this fight about interpretive methodology, continue to interpret the Constitution through sort of a bricolage, the way they interpret many documents. They look at text and intent and intentions of the people that framed and practices thereafter. They look at ongoing social practices. They look at existing norms. And that's the very kinds of language we could use. It's the language we use, most of us, when we write briefs. Somebody asked me earlier, does that mean we have to avoid theory? No, absolutely not. I think we should draw theory from anywhere we can, from economics, from sociology, anything that helps us understand the document and how to read it and how to constitute ourselves as a society, which is what I think we're basically doing, we should do. And certainly, high up on that list, hard to imagine that we would interpret in any way otherwise, would be including history.
All right. I really like this, Judge, and I wish I had one of my own. I'd like to thank Michael McConnell and the Stanford Constitutional Law Center for putting on a wonderful conference. I really have learned a lot from all the presentations, and I appreciate the fact that you're still here on the second day. I must say I wasn't sure why Michael thought that I would be suited for this panel on the future of history and constitutional law. Perhaps he heard that I picked the Seahawks over the Broncos by 30 points. I also predicted the first black president, namely Bill Clinton. And my next prediction is that we will continue to see history cited in constitutional opinions from the courts, the executives, and Congress, and we will continue to see historical arguments in legal scholarship. First, a little anecdotal evidence of where we are now. And where we've been. In 1993, Erwin Chemerinsky, no friend to historical argument, claimed that historical argumentation was rampant in the Supreme Court. He phrased it in terms of tradition, saying that, quote, in virtually every area of constitutional law, the Supreme Court increasingly is relying on tradition as its guide in decision-making, unquote, and he bemoaned that fact. Of course, 1993 is ancient history. Writing in 2013, Joshua Stein, a Yale law student, notes that professional historians have submitted 32 briefs in the Supreme Court since 2006. 32 briefs over 7 years by professional historians. That seems rather high to me. And of course, we heard earlier today that Professor Rakoff has been one of those submitters of briefs. And this number actually understates the number of briefs that are making historical arguments, of course, right? Because it's only briefs by historians. Mr. Stein didn't look at all the briefs that were making primarily historical arguments. So at a minimum, the number suggests that a good number of professional historians believe that history matters to the court and that their submissions might influence the court. Why will we continue to see history cited by constitutional interpreters? I think in part it's because originalism is somewhat triumphant. When folks like Ronald Dworkin and Jack Balkin say that they are originalists, when David Souter issues an opinion in print and says that the Federalist Papers help him reach that decision, are decisive in that case, we have something of a phenomenon. When David Strauss, in his book about the living Constitution, argues that the framers consciously used specific texts when the stakes were low, and more capacious text when the stakes were high. He's making an originalist claim. I'm not sure he's right, but I think it's surprising to find in a book called The Living Constitution a claim that the original Constitution itself left itself open to living constitutionalism in those areas where it is most needed. But it is not just that originalism, for all its flaws, has won the day. It is also because lawyers find history useful and comforting. Judge Richard Posner, no friend of history, observes, quote, law is the most historically oriented, or if you like, the most backward-looking, the most, quote, past-dependent, unquote, of the professions. It venerates tradition, precedent, pedigree, ritual, custom, ancient practices, ancient texts, archaic terminology, maturity, wisdom, seniority, gerontocracy, and interpretation conceived of as a method of recovering history. This is not praise, but it is a descriptive lament of the world we live in. If we look to Philip Bobbitt's 6 different modalities of constitutional argument, something that Keith Whittington referred to earlier today, Bobbitt lists 6 different modalities, what Barry called bricolage: textual, structural, historical, doctrinal, prudential, and ethical. It is hard to think of one that does not welcome resort to history. Right? The relationship between historical argument and history is obvious. New originalism, old originalism, or historical practice as a gloss on the meaning of words in the Frankfurtian sense all make heavy recourse to history. But the same can be said of all the other modalities. What is recourse to doctrine, judicial doctrine, except a claim that some decision or decisions in the past help us resolve a current dispute, and making sense of judicial doctrine requires some recourse to history. Text might not seem to require recourse to history, but textual argument often relies upon some perceived understanding of the text in the past. Often the best textual arguments are usually sensitive to the context of the text creation. Structural arguments might seem potentially ahistorical, but think of Marshall's argument in Marbury about the nature of written constitutions. Marshall says that the theory of written constitutions is that they will be treated as law that the judges may enforce. I think this argument is only plausible because of his sense that all written constitutions prior to that point were judicially enforceable. The structural argument that writtenness implies enforceability is really an historical argument, even though it's not phrased as such. And I think, to borrow from Stephen Sachs, Marshall's structural argument relies upon a constitutional backdrop about the nature of a written constitution. Prudential arguments turn on consequences of certain decisions. Oftentimes, the consequences of some legal argument will be judged by reference to what happened in the past. In McCulloch, Marshall adverts to the clear utility of the Bank of the United States over the previous decades, an argument that sounds in history to me. One can also think of the claim by Justice Stephen Breyer in United States v. Lopez that the court's decision in that case resurrects formal distinctions that history has shown were misbegotten. Even ethical arguments can have a historical component. Bobbitt defined ethical argumentation as deriving rules from those moral commitments of the American ethos that are reflected in the Constitution. It seems to me that discovering the moral commitments that are reflected in the Constitution is at least in part an historical inquiry. Why is history so frequently resorted to in American constitutional law? I think first, history is comforting. Knowing that something has been done before or that it has been around for a long time makes it seem more acceptable. Secondarily, history allows us to deflect responsibility. Citing history, a judge can ascribe responsibility to some decision in the past and attempt to avoid responsibility for their decisions. All in all, I'm tempted to say that we are stuck with a legal discourse that will be saturated with history for quite a long time, to use a phrase that Bob Gordon used yesterday. That means that we will always have law office history because judges can't be specialists in everything. I recall that whenever I took a specialized class in law school, the professor would point out how the Supreme Court just didn't understand tax law or didn't understand securities law or didn't understand bankruptcy law. And that's the lament of every specialist. And so it's not unique to history. We're always going to have law office history done by judges and justices and, dare I say, law scholars as well. And I think that means that historians will continue to gnash their teeth about real and supposed blunders. The claim that the use of history by the court constitutes, quote, an illicit affair, unquote, only makes sense from the point of view of historians who view the muse as particularly theirs. I think that was and is a mistake. Clio was never theirs, at least not exclusively. Thank you.
Well, since I told you that you have to vote, and that's something that I always have to do, and it's something that I think that I've noticed that it's very easy to criticize what other people's opinions, but then to come up with a better one or to actually make a decision can be very different. So I think before we vote, I'm going to give each person an opportunity for rebuttal. And I think my originalist terrorist to my right, Mike, you might want to have something to say about what Barry said?
Not too much.
Is he right?
We have different views about these matters, and I guess the question is, that you can look at these questions from different perspectives. You can have a normative question about, what is the legitimacy of judges not following an originalist path. I obviously have problems with that, but other people have a different approach to things. I suppose you can have an interpretive questions about whether or not really what would be going on in that situation is interpreting the Constitution, or is it doing something else, and what justifies that. So, these would be the questions that I would ask.
Barry,
are you surprised?
No, Mike and I did this 2 weeks ago. But I think what I would just say is, so I don't think originalism's been triumphant in any imaginable way. I mean, I can't count very high the number of judges that are originalists in any way that the originalists in the room would count. I do think originalism and the push toward originalism did us all a terrific, important favor, which is that, if you go back and read Paul Brest's sort of original piece about the living Constitution, it's a wonder to read. I mean, you should go read it, because I don't know what exactly he was thinking when he suggested that we just sort of, dump all pretense to interpreting the Constitution as a historical text and make the best of it that we can. And I think originalists did us all a favor in reminding us that we had to go back to the text and that we had to go back to history. And I think Sy gives a very wonderful account of the pervasiveness of history. I agree completely. I think it's here to stay, and the better that we do it, the better. And I guess the last thing I just want to say is, Justice Souter and Prince, I mean, that was just embarrassing, right? I mean, it's like he didn't know the answer, but then he picked up the Federalist Papers and it was clear to him. I mean, it couldn't. Anyway, I hope that was more going on there than that. But.
Well, Sy, you probably have your history is most entrenched with clerking, I think, probably from that standpoint. And so what would your response be?
Well, I like my claim that originalism is triumphant is obviously just, something I said to be provocative. I don't really believe it in the sense that everyone's an originalist now, even though some people have actually said as much. What I mean is, if you look at Supreme Court briefs, if you look at Supreme Court arguments, if you look at Supreme Court opinions, they're much more historicist in nature, or at least at the very least they're making historical claims of the sort that weren't always there in the past. And I think, as some people have acknowledged over the course of 2 days, originalism has affected the terms of the debate. And so I understand the need to get beyond arguments about what we ought to do and instead just doing what ought to be done. But I also think that in saying that, we have to realize that these arguments do matter, because it's actually, it seems to me, has moved the needle quite a bit, because it's changed the way that arguments are being framed by the lawyers. It's changing the way that judges are deciding, or at least framing the text of their opinions, and it's changing what scholars are doing. I can't read behind, or I can't look into the minds of judges and say why it is that opinions like Heller or opinions like Thornton, which is the term limits case, and other cases seem to be argued almost exclusively on originalist grounds, and whether that's actually what's going on in the head or something else is going on in the head. But it does seem significant that there's this very different sort of argumentation that's going on, and it's happened in the last 30 years.
Can I ask a question?
Yes.
Which one? I just have a terminological question. So I take it to be, though, that history isn't originalism, but in both directions, in the sense that there's lots of history used in Supreme Court decisions that nobody would deem to be originalist. I mean, it's history that may start at the founding and moves all the way up to the present. So it's a historicist account of what's happened in the country. And then I also take from Mike that there can be originalism that isn't historical in a certain way, but can be grounded in more legal text. So I just want to make sure I'm understanding.
I agree with that. What I was saying earlier was not a claim that originalism informs all those types of argumentation. It's just that there are quite a few cases from the Supreme Court, and the opinions are written in originalist terms, both the majority opinion and the dissent. And what's striking is that members of the dissent don't just say, this is what I think the original Constitution means, but that doesn't even matter. What really matters is what we take it to mean today. And the four of us take it to mean something radically different than what the original meaning was. Or that's sort of beside the point. You're just arguing the wrong sort of thing. And there is something of a capitulation of non-originalist folks in areas, at least, where the issue seems almost one of first impression for the court, right? Because at that point, it seems like they're on terra nova and they're trying to decide what to do, and the default position seems to be, let's use originalism, and that's an interesting phenomenon, it seems to me.
Well, were you surprised? Were you surprised by, you clerk for Justice Thomas, were you surprised by Justice Thomas's dissent in the violent video game case?
Well, I
wrote the opinion for the Court of Appeal, and so when it was...
Right. Well,
and usually I get Justice Thomas's vote. So I was a little surprised. I was wondering if you were surprised.
Well, it's not my area, and I love the justice, but I may have some of the same views that Mike Ramsey expressed, and I'll leave it at that.
Mike?
So one thing about sort of the change that's happened over the last decades is, I guess I would say, if you went back to the 1970s, originalism didn't really have a place at the table, right? So people sort of felt, they could talk and they didn't sort of worry about any real serious originalist argument being made in any sort of serious way. And so what happens in a sort of culture of that sort is you don't pay attention to those kind of arguments, and you make other arguments, and you get further and further away to a point. Now maybe you're sort of out on a limb in a way. So, and then what's happened over the last 30, 40 years, whatever, is that originalism has sort of fought its way to get a place at the table where it gets to make arguments, and people know that those arguments are going to be made, and they have to anticipate those arguments. And not that it's triumphant in the sense that everybody's an originalist. And so then the interesting question is sort of, where do we go from here? And there's obviously lots of possibilities. So one possibility is that originalism, recedes, or we continue in this kind of state of battle. Right? If you look at American history, certainly there's always largely been two parties and two different contending views about the Constitution. So one possibility is to imagine that we continue to have contending views, but they're all originalist versions, right? So there's Justice Scalia's originalism and there's Jack Balkin's originalism, and the fight occurs within originalism, right? So in a sense, that would be originalism triumphant. In another sense, maybe not. Depends what you think about the different versions. So that could be, or we could continue to have, sort of moderate originalism that takes, it says originalism is very, very important, more important than we previously recognized, but of course we can depart in certain ways. Maybe a view that seems similar to what Eugene Volokh was talking about earlier. So which way the future goes on this is sort of, there's lots of possibilities. I'm sure of one thing, though, that we're going to have different views of the Constitution, and it'd be hard to imagine two different parties not having two different views of the Constitution. Maybe that's too simple a way to think about it. And really, in a way, the question is, do those views get mediated within originalism, or do they get mediated through originalism in some alternative version, or maybe originalism is not even at the table any longer?
All right, time to vote. All right.
Vote for me.
All right.
Let's vote on whether we
now
vote.
You have to raise your hand, and I think they're all watching.
Can I say something?
Yes, you can.
So, as a child, we used to sometimes pick teams, and there'd be two captains, and I was always picked last. So I want you to think about that as you
I'm going to vote for you.
All right, Team Mike, hands up. Oh, he got one. Okay. Team Cy. Oh, Team Mike. Oh, you got more. All right. Team Cy. Oh, that last.
Do we get to vote?
You would vote for yourself. All right, and Team Barry. All right, well, it was fairly evenly split. So
I think Cy won.
I think it was his last minute sympathy play that pulled it together. So we'd like to take questions from the audience. Are you all too tired?
Maybe.
Oh, good.
Two questions. We discussed history. That's one branch of human science study, etc. There's economics, there's physics, there's lots of other areas which people have explored.
Why do we get this idea that the only thing the judges will talk about in their results is Originalism history? Why shouldn't they take advantage of all of human knowledge rather than this one limited one? Second one, which is either answerable or not, is originalism parallel to conservatism and activism parallel to progressivism, or are they perpendicular?
So if the judge's role is to decide cases according to law, then they have to look at things which are relevant to the law, right? So it depends on your theory of law. So the theory of original meaning, to a large extent, is the original meaning is the law. So that's why you would look towards that, not to all history, but just to what might be relevant to that. You might have a theory of law, or particular laws might require you to look to different kinds of considerations, and you might look to those.
I mean, look, judges have been looking at all that stuff for as long as they've been judging, or at least certainly I've been reading Supreme Court opinions. I mean, they look to history, but they look to consequential arguments, some of which are economic or incentive-based, assumptions about psychological behavior. They make moral arguments. This is Bobbitt's exercise, which is to take an opinion and sort of underline all the parts of it that reflected all these different modalities of reasoning. And then Keith, of course, brought up the, I can't remember how you put it today at lunch, but because I said so argument, very important for judges. So I don't think they've ever been limited in any particular way.
I agree. This is a panel on the future of history, so we're kind of focusing on that, but the judges will use other things in their decision-making process as well. It's not just history. It's not just originalism. As a descriptive matter, they're looking at more than just history and originalism. And on your second point, there are originalist types who believe not in judicial activism, but what they call judicial engagement, which by which they mean, I think, judicial activism. And so it is possible to be an originalist but believe that the court should more vigorously enforce limitations on legislative majorities. So there's no necessary connection between being an originalist and believing in conservative views as opposed to libertarian views, or as opposed to Jack Balkin's more progressive views.
And I would say, actually, so originalism starts out, and I think it's fair to say that, certainly within the early years, it's largely conservative people who are originalists. And so, not surprisingly, the history that's brought to bear has a sort of conservative bias, if you will, conservative viewpoint on it. And it's sort of noticeable when you see libertarians, or the next group who starts to move within originalism are libertarians, and they take a different viewpoint, and they raise challenges to the conservatives and prevail in a lot of different respects. I think the sort of movement away from judicial restraint to a sort of more neutral view is in part the result of challenges brought forth by libertarians. And more recently, you have more liberal originalists who bring up arguments from that perspective, and it transforms the area. So, I mean, I think it's undeniable that if you look at the early originalists, they were very often relying on sort of conservative views of the history, but the broadening of these matters has improved originalism and changed it.
Yes.
I wanted to pick up on something that Barry said, which is, if our Constitution was written last week, then obviously this conversation would be very different. The idea of original meaning is kind of like, well, we know what it means, right? So I wondered, since the whole thing is about the future and the crystal ball, if you guys could project a little bit, the history of sort of statutory law in the United States is kind of like this, right? There's like nothing at the base of the pyramid. Most of our, median age of a statute is obviously different than the median age of the Constitution or the amendment. So, if you play things out, 100 years from now, maybe we're still living under a lot of statutes currently. Do you see, sort of an ever-increasing role for originalism in statutory interpretation?
Yeah. So it's funny when Barry, I have written down here, so Barry said that that our problem is that we have an old Constitution. I kind of wondered, I sort of scratched my head and sort of wondered, boy, we really do have very similar kinds of debates about statutory interpretation. It's sometimes said, oh, well, in statutory interpretation, everybody's, I don't know, an intentionalist of some sort, but that's not really true. I mean, even if even people who it's the same kind of arguments you have made sometimes about the Constitution and the intent. There's a sort of looser version and a stricter version. So, I mean, I think we have very similar debates about statutory interpretation, and lots of these statutes are fairly recent. So it suggests something, not that the Constitution isn't different, it's shorter. It is older, so, but there's something deeper going on here that has to do, I think, with the role of the judge and what is legitimate, and so I'm not sure it's about old.
I view statutory interpretation very differently than constitutional adjudication for the simple reason that it can be easily changed if someone thinks you got it wrong. If you interpret a statute, then the legislature or Congress can come back and say, no, that's not what we meant. Whereas constitutionally, once it, like, for example, certainly with the Supreme Court, but once it becomes engrafted, there is no change but for a constitutional amendment, essentially. I mean, that's judges generally, I think.
Other than Roe versus Wade and Bowers versus Hardwick and Furman versus Georgia and the cases that get changed, but they get changed by judges eventually.
But very slowly. And
yes.
If you're an intermediate court, and many courts are, with the exception of 9 people, then there is, regardless of what a judge's view is of stare decisis, it does take a long time to change something that the Supreme Court has said, and you need to be able to count to 5.
I mean, I think it's not exactly responsive to your point, but one of the things that happens when people say, it is very difficult to get a constitutional amendment, and therefore, and I'm not saying that you're saying this, but and therefore, what a common argument is that judges need to update the Constitution and to take that into account when deciding cases. And it's certainly true, it's more difficult to get a constitutional amendment. On the other hand, what ends up happening is that ends up being a self-fulfilling prophecy. So how can you get, we've had constitutional amendments throughout history. How can you get a constitutional amendment? The only way you get a constitutional amendment is if there's a consensus that there's something wrong with the Constitution and it needs to be changed. But if what the judicial role is to sort of update the Constitution when, a majority of the people, and that's good sometimes, but when a majority of the people think this is a bad thing, well, we're going to adjust the Constitution in order to make it right, then you will never get a constitutional amendment, because before there's an opportunity for something to develop a consensus, the court will have changed it already. So there's a kind of substitution effect. There's a crowding out. You can have judicial updating, or you can have constitutional amendments. It's very hard to have both. There might be certain areas where judges can't act, and I think it's a very troubling aspect of our modern times that we have so few constitutional amendments, and no one takes it seriously any longer. There almost isn't an infrastructure for it any longer, and one hears all kind of arguments. Well, our Constitution is just so beautiful, we don't want to touch it, and it's a serious problem.
I just finished reading a book-length manuscript by a young historian, which is essentially about the invention of originalism. Mike is actually somebody you should invite to San Diego, because I think it would be quite good. And it got me thinking about this exchange in 2 ways. I mean, to Barry's early remark, one of the curious things about the history is that originalist interpretation emerges pretty quickly, within 5 to 7 years, depending on exactly how you want to date it, after the Constitution was originally propounded. So that kind of goes to your little, to your little chronological riff there. On the other hand, to come back to Mike's point, one of the things that puzzles me about original methods, originalism, is since I think the whole idea of constitutional law and constitutional interpretation in the American style was a great innovation after either 1787 or arguably after 1776. The idea that there would have been original methods, originalism, strikes me as being counterintuitive. Namely that, in the sense that nothing like this had ever really been practiced. I don't think a field known as constitutional law existed in any serious or substantive sense of the term before you actually have a written constitution adopted at one moment, a supreme fundamental law recognized. So you have to, I'm not saying you have to make it up as you go along. There are a variety of interpretive techniques out there that you could start to deploy, but the question of how you deploy them was very much a matter of argument in the early 1790s. I have to say, this manuscript is quite good. I mean, I tried to do something like this in the last chapter of Original Meanings, pivoting on Madison as arguably the first originalist. The argument here actually is originalism becomes more deeply rooted than many of us would have recognized, at least if he's right, at a relatively early point. But I think the basic point still stands. If you want to think about some of the claims you were making about original methods, originalism strike us as being kind of a bit wild in the sense that it presupposes a lot about something that had yet to be created and was distinctly innovative. It was subject to lots of political incentives and opportunities, and I think it remained a subject of kind of active debate and controversy for some time thereafter, including our own time. So it's not a question there, but it's a kind of point. It's a kind of rejoinder to what the two of you were saying that I think in some ways is apposite to this discussion.
Well, I guess I just don't think that. I think partially that's true, but when you look at the enactment of the Constitution, it is against a background, and I've made this point in the questions earlier today, of having lots of state constitutions. There's 11 state constitutions enacted. There's more of them, so they're changing it. And I forget how many cases Bill Traynor comes up with, but there's 30 or 40 cases. Now, not all of them are pre-U.S. Constitution cases, but there's a significant number. So we can look at how courts interpreted Constitution. By and large, the interpretation of constitutions was very similar to statutes. Jefferson Powell takes this view, and it's my view as well, that the Constitution was kind of a super statute. It was. And now it's distinctive in the sense that it's has a certain length. It's designed to endure for longer periods. But the interesting thing is, do you read cases where people say, oh my God, this is a constitution. We don't know how to interpret it. You don't actually see that. What the people do is they use their traditional techniques. There's occasionally some adjustments, and I think that's largely because the prior understanding of the state constitutions, which they were relying upon, people at the convention generally assumed that there was going to be judicial review, had done the same thing.
Okay, so there are two responses here. One is the first state constitutions were not constitutions in the full sense of the term. This is what I like to refer to as the legacy consideration of yours and various problem.
Oh yeah, that problem.
Means no translation here.
If you want a response, you do.
Which in fact is a major part of the development of constitutional theory. Between 1776 and 1787, Madison, Jefferson, the rest of it. Secondly, most of the constitutional interpretation, this is what Jonathan Gaddafi is the author of this manuscript. Most of it's actually taking place in Congress. It actually starts with the so-called, what I said last week, the decision of 1789, that Sahi has also, I guess, contributed to. So his first chapter is actually about the removal of the paper. So you can't assume, you can't reduce it, or you can't fully equate it with existing norms of statutory construction because it's taking place in a highly politicized context where a variety of other concerns and considerations are place. So I think that's one reason to think that since so much of American constitutionalism, as it's disputed, let's say even in the first decade and a half after 1787 or 89, is primarily a political and not a function that you have to have a different, kind of trope or whatever, different, framing perspective for asking, how do early originalist theories apply.
What was the first point? Just.
I forgot what the first point I made. Oh, first point I made. Legacy posterior superiority. Okay, so it is a well-known maxim of statutory construction that later statutes contradicting earlier ones, abrogate. And one of the fundamental problems of American constitutionalism after 1776 is that all the state constitutions, until you get to Massachusetts, were promulgated but not ratified. So therefore, and they were promulgated by bodies that were essentially legislative in nature, and therefore their juridical quality or whatever was essentially, you could say super statutory, but might as well just say statutory. So they're essentially statutory in nature. So the question of how you distinguish constitutional interpretation from statutory interpretation is, I think, to some extent left open because there are different conditions that apply to what is legal authority to the different kinds of tests, which actually I think ties in with the supermajority arguments, but distinguishes one kind of constitution from another.
So 2 points. So first of all, you're absolutely right that there were problems. They were figuring out, as we discussed earlier, how to get constitutions to be higher law. But they assumed that constitutions were higher law. They didn't have all of it worked out, and that's why judicial review, when it gets exercised at the state level, actually occurs. It's all of a stronger argument in favor of the existence of judicial review, in that it exists even though there isn't a special way of enacting constitutions. That's first. And second, the argument is sometimes made, and I guess it depends on the version of originalism that you have, that originalism starts, 7 years in the 1790s. I guess it sort of depends. So Hamilton writes the opinion on the bank early on, and he says, we use the ordinary rules of interpretation here, and we don't look to, if memory serves, we don't look to what was considered and rejected, but we look to the ordinary meanings. I think that's originalism. It may be overlapped with other things, but I don't think. I think that's I wouldn't say, oh, that's non-originalism, and they invent originalism later on. The originalism gets a certain form because they're fighting in a debate, but I don't think the earlier decision by Hamilton is
I guess the
not
kind of originalism I'm talking about. Somebody made reference to this. Passage referring to the records of ratification. Passage tries both what was discussed in Philadelphia and then the records of ratification. So it seems to me that is more what I call a historically grounded originalism than one that's purely, more strongly linguistically based.
Mike?
I do have a question, but do you mind if I first enter into this? Because I'm very curious what you mean, Mike, when you say that Hamilton's argument on that score was originalism, because basically the bank, one of the big arguments against the bank, Jefferson makes it, Madison makes it, is that Madison made a motion at the convention to empower Congress to be able to incorporate, and that was voted down. And I think the reason Hamilton says what you quote him as saying is that he's well aware that that's a point against his argument, and so he says, well, we don't want to look at that. The others are looking at it. Seems to me original methods is some of them say to look at it, some of them say not to look at it, and I don't understand why you identify Hamilton's position as originalism.
Well, I'm not saying that it's the only originalism, so Hamilton, maybe for strategic reasons, maybe for other reasons, says, the way we typically interpret laws is to look at the ordinary meanings. We don't look at what people voted for in the legislature. So that's a sort of original public meaning version of originalism, if you will, as opposed to an original intent version of it. And of course, I believe he makes the point that, well, they voted down that for different reasons. It's not, it's distinguishable. But that's the basic argument is that it seems to me that he's making an original public meaning version, and Madison and others or Jefferson is making an original intent version.
Well, I can see that the fact that Hamilton made the argument might make that an originalist argument for us, but Hamilton didn't say the reason I'm making this argument is because the framers and ratifiers of the Constitution thought we would read the Constitution this way. It was just a litigating position.
No, I don't think.
Sorry. Go ahead.
I don't think it's really just a litigating position. So if you're the first generation, right? If you're using the language, you're an originalist in that generation is going to look very different than an originalist, from 100 years later, right? So we've got sort of translation questions, and we have to sort of understand the language. So when he says, I'm just going to look to the ordinary meanings of these materials, that can be very much originalist because he knows the meanings of the terms in the way that people from many years later will not understand them.
I hear deep breathing with Barry here. He needs to say something.
Oh, actually, what I want to do is just rest my case. So when I'm sitting and listening to a conversation and I can't figure out what's at stake, then I think, either I'm not that clever, which is definitely a possibility, or maybe nothing's at stake. And so I did get what was going on when originalism was all the fight in the 1980s. There was something seriously at stake. But once it's originalisms and different versions of originalisms, and I was serious yesterday or today, I can't remember which day it is at this point, but when I said, does nobody see the irony in the new originalism? I mean, at some point it's worth asking, what are we fighting about exactly? So, because if we knew, then I definitely would jump in, but I don't know. So I just have to sit on the side and say, I wish we'd fight about something else that felt like it meant something more to me.
Can I respond to that? I think insofar as people are having an intramural squabble amongst themselves about which version of originalism is better, I kind of understand Barry's point. But if it's the case that legal argumentation has changed and the way we argue before a court has changed and the way courts write opinions has changed, unless you're able to show that that's all just a farce, then it's the overall debate has had an effect whether or not particular claims about particular clauses or particular claims about particular methodologies are worth fighting over. So I guess the question I'd have for Barry is, do you believe the legal discourse has changed amongst people arguing before the Supreme Court and amongst justices of the Supreme Court? And if so, what's the cause? Is it in spite of all the people who are writing about originalism because of it, or some other factor?
But you know my answer. I mean, I already gave it away a little bit ago, which is I agree with you that the movement that took aim at the living Constitution and insisted on originalism caught everybody's attention and forced us all to focus more on text and history, and I think that is a good thing. And so, I've written an originalist defense of the Dormant Commerce Clause just because people thought it couldn't be done, and I've written an originalist argument about why Champion versus Ames is wrong. But I agree wholeheartedly, and my point, because I think it is an important point, is, and I'm also, look, if we all had to justify our academic projects, we'd all be out of work. But my plea is just I think that constitutional lawyers play a relatively important role in society, and that role for a long time. Will Baud and I were talking about Alex Bickel last night. People that really were giants and that contributed to the world in an important way. I just feel like the originalism project kind of just kept going when it didn't need to keep going, and it became an intramural project, and I'm just saying, great, we've learned a lot. Maybe now let's talk about something else.
But what happens is...
The super new originalism, then?
The new originalism.
No, but what happens is the ideas attract new people, and they come and look at the ideas, and older people look at the ideas, and there seems to be problems with things, and you want the ideas to be as good as possible, to be as defensible as possible. Now maybe that's a sort of academic excess to want to get it right, but I think that's what's at stake is people. maybe it doesn't have a practical import. I think it does, actually. But even if it didn't, there's the desire on people to get it right.
So first of all, again, we're all given academic excess. Goodness knows. But I think the point is that like Sai's exactly right. We were all taught an important lesson at some point in the 1980s and 1990s, and I think everybody adjusted, and they adjusted from Ronald Dworkin's adjusting, and everybody's adjusting. But I also think it's fair to say that we learned that neither originalism, as it was kind of set out as a creed, nor living constitutionalism was an accurate description of what we did or ought to be doing, and we learned that lesson, and we adjusted, and we moved on. And I'm not sure any fine-tuning of originalism is going to make it, clear that that's what we should be doing at this point. And so, again, I'm not going to begrudge anybody their academic project. It's just that I know a lot of you guys, and you're smart guys, and I wish I could get you to fight with me about something else.
I just want to respond. I think this is really smart. And so the question is, do you think that saying something over and over again makes a difference? And I have children, and they say, you've already told this to me, so stop telling me this, right? I mean, you've already told me this. Why are you telling me this again? And it's because I don't think you're going to do it. So if Barry's right and originalism is at its high mark, well, then what's the point of going on unless you just want to keep it at the high mark? If, on the other hand, you think there's a chance it'll be even more used, right, that Justice Breyer sees the light and becomes like a full-fledged originalist, then you could see why you would do it. And I think Barry is assuming that you've gone as high as you're going to go, just, maybe maintain it, right, whatever level of argumentation and of obsession you need to maintain it. But you're not going to get any higher, and so there's no point in constantly beating this drum and beating different drums that produce slightly different sounds, but all make a percussive sound. And I understand that, but it's a question about the future that we don't know, right? Because if in fact people like Mike and others have this debate about new originalism and new originalism and what have you, and it actually changes what lawyers are doing and what courts are doing, then it does matter. And we don't know whether it's going to matter by sitting here and talking about it. I understand why you'd be skeptical of it, but someone like you might have been skeptical in the 1970s. Why are we talking about originalism? It's obviously wrong. That was the claim in the 1970s and 80s, right? And I think there are many people on the faculty, not you, of many law schools that say that it's a silly theory. It's not worth talking about, notwithstanding the fact that 9 justices have written opinions that are all originalism based. But so I understand your point, but I think it depends upon a claim about the future that we don't know.
Well, here's an ironic just twist on that, which is for your argument to be, I can think of a version of your argument that actually ends up being right. Okay, so my
Cheers.
Well, now listen. So
Barry, my back is killing me.
So I just want to say, I actually think that what's happening now with originalism is hurting originalism as a argument in the public sphere, and that it was better as a sort of hammer on the table argument that wasn't too refined. Now, what might make it's true. Now, what might prove me completely wrong is if these guys all manage to work into a version of originalism that everybody finally sits back and says, oh yeah, like that one works. That one doesn't have problems. We're going to all do that one. I just think there's a vanishingly small chance of that happening.
I'll take a comment or a question or a solution.
Well, I think a clarification of what I think is at stake, at least partially. And let me go back to the Bank and McCulloch. So my understanding is that Madison has this proposal at the convention, and not that it's voted down, but that they don't vote on it. And they don't vote on it in part because they're afraid it will be voted down, and that'll set a precedent. And in part because this concerns, Kurt, you're saying no. You're saying they do vote. It's voted down. Okay, so it's voted down at the convention. Okay, Marshall knows, right? I mean, Marshall doesn't mention this history, right? He doesn't mention this originalist history, and he makes originalist arguments in favor of the bank. It's not a great substantive and independent power, right? Even though he knows what happened at the convention and he's not mentioning it. So for me, what's at stake is whether judges are taking responsibility or whether they're evading responsibility through gestures to originalism. Now, Sai, you said almost in passing that one of the reasons why judges may consult originalism is some kind of avoidance, or they have to attribute responsibility for the decision to something, and so they attribute it to the past. And ought we to feel good about that if that's how originalism is being used? It's really striking how selective any justice you care to name is in being originalist. You can talk about Heller, you can talk about Crawford, but then you get parents involved in which they're debating the original meaning of Brown. The 14th Amendment doesn't exist. It's who can lay claim to the mantle of Brown. You get to Heller, right? That some have called the best example of public meaning originalism that we have. Think about how many non-originalist moves Justice Scalia makes in that opinion, right? I mean, what's the evidence he looks at? It's not just post-ratification history in the early 1800s. It's post-ratification history 100 years later. So now it's history as tradition, as common law evolution, not as originalism. What's his argument for why handguns, which is what's really at stake, handguns, which is what criminals want and public authorities are concerned about, why does handguns included within the scope of the right, notwithstanding how stupid it is for the vast majority of people who are not trained to use handguns at close range in terrifying situations, right? Most Americans prefer that. That's why handguns are not shotguns.
An example of a good originalist opinion? I haven't heard one academic cite one, and I would also like one that you disagree with.
What about the list of don't worries at the end of the opinion that Justice Scalia articulates? He's saying, "Don't worry, we're not crazy." And by the way, you can't even have the very weapons you would need to participate in a militia to resist federal tyranny today. Right, so this is the example of original. Now, there's a lot of talk about the original meaning and don't look at us. The Constitution's making us do it, but then he's doing all kinds of stuff that is very presentist and very careful and prudent. And so it's not a good thing to me for judges to consult originalism kind of sort of just in order to evade the responsibility for what they're doing in the present, and they don't really have to be doing.
Neil, my claim was about history, not about originalism. Right?
So let me finish. Until Barry corrected you.
Let me finish. Right. So what you're describing is just going to be true of judicial argumentation generally. I mean, you can always say that they're bad at economics and they're bad at history and they're bad at originalism, they're bad at text, they're bad at all these things, and it's all true because they're generalists, right? They're not people who have a degree in economics and who have a degree in history and who have a degree in, all sorts of other disciplines that might be useful to the decision. So I'm not denying that what you're saying is true. In fact, as you said, I said that they're going to use history as a reason for what they're doing, but that's true whether it's a doctrinal reason or any other of the reasons that Bobbitt talks about. So what you're saying is just true generally. It's not true particularly of originalism. So unless you're going to say they can't give any reasons because they're likely to give us bad reasons or poorly thought out reasons, then I don't know what the point of the comment is. It's not peculiar to originalism that people make bad originalist arguments.
But it is peculiar to self-described originalists to spend a lot of time proselytizing and say you're either an originalist or you're making it all up. Right? You hear that from justices who describe themselves as originalists. You don't hear that from the kind of common law, pragmatist justices or other judges who, Justice Stevens says, I'm exercising reasoned judgment in McDonald. And what does Justice Scalia do? He rakes them over the coals for licensing judicial whimsy. Because all Justice Scalia is doing in those cases is just calling balls and strikes and looking at the law and applying it to the case. So I think there's a certain kind of rhetoric in politics surrounding certain kinds of originalism, not careful academics, that I don't think is true of the more traditional common law judges.
Look, sure, there's always a bit of moralizing about what the other side is doing, and there probably was a time when judges were just making it up. And so maybe Justice Scalia is referring to that time. I don't think it's peculiar to Justice Scalia. I can't imagine that Justice Stevens hasn't said the same thing about Justice Scalia. So I think it's unfair to say that because justices in the heat of the moment claim that the other side is making it up, that's something that's only said by originalists. I just don't think that's true. I'm quite positive that Justice Stevens has said the same thing about a majority opinion that he did not like. And perhaps said it from an originalist perspective, but even whether it's from an originalist perspective or not, it's still a claim about someone else's motives that ascribes bad motives to them. So I just don't think it's peculiar to originalists to say you're making it up. I think there are all kinds of judges who would say that about another judge, regardless of whether they're originalists or not.
I can attest to that.
I guess this is mostly to Barry. A brief plea in defense of a lot of the intramural debates that you find tedious and academic. I'm sorry you find them tedious and academic, but I'm glad you're here. I think I think some of this may be a little bit generational, if I may. I mean, some of us do not.
I'm old. You're tedious and academic.
Some of us were in elementary school in the 1980s. Some of us read Bork and Scalia's arguments for originalism and thought they were not very persuasive, and then read the new originalism and said, oh, this is much different, much better, it really makes a change and an improvement. And a lot of that, I think the arguments are different. They attract new adherents. The students in my originalism seminar have very different reactions to some of the kind of new originalism than they do to the old originalism, much more favorable reactions. And I think it's an important, I think there's been a lot of changes. I think sometimes people who come in not having read originalist scholarship for the past 20 years find their critiques like misfire because they're challenging assumptions that are no longer the assumptions like any of the originalists are making. I think one particular change has been, and one thing people are fighting about a lot, is this relationship of sort of how much is originalism just sort of ordinary interpretation? So how much is Hamilton when he talks about just like doing ordinary statutory interpretation, is that originalist? And how much is sort of just the ordinary discipline of law, like lawyers' work, tell us what the right historical questions are to ask? I think sometimes that can sound kind of academic when we start talking about it, because legal theory often sounds academic, but I guess I think it's been a really important advance. And made a lot of difference.
I mean, I do not deny anyone their academic project. When people ask me about academic projects all the time, I give them pretty much the same advice. Well, unless they want to get a job on the market, but then I tell them to do securities law. But the advice I give them is to follow your heart. And I understand exactly the history of originalisms, which is, it got launched, it grabbed public stage, there was a big backlash, and then there were responses to that, and then off we were running. Meanwhile, just to be clear, the left is still tearing out its hair to try to figure out what to say in response at some level. And I think it's great as an academic project. I just do think that at some point it's distracted a lot of us from. I mean, I miss the old days when we were fighting about stuff, and I kind of want to go back to that.
So if originalism has taken the attention of all of us over the past, say, 40 years or so, as the chronology is laid out, that may be true in the United States, but looking beyond our borders, I wonder whether the panelists have anything to say about recent articles that have been written by, say, Jack Balkin or Jamal Green, who have said that originalism, however understood, is for the most part has been sort of an American exception, American sort of exceptional practice, and it's not really taken root in many other places. There may be some instances, perhaps in Australia, but for the most part, not really existent. But you think, given the way originalism has been defended as sort of a way of sort of fixing legal meaning or a written constitution, sort of democratically sort of arranged constitution, we think that it would sort of on its own terms, on its own merits, have eventually sort of made more of an appearance. So peering into that crystal ball, I'd be curious to see if you think over the next 40 years or whenever other countries, other jurists in other countries might take originalism more seriously, or whether you think it is actually more practice than is suggested by every country.
So last week at the San Diego Originalism Conference, we had a paper done by a woman, Yvonne Tu, about originalism in other places, and a lot of this came up. So of course there's Australia where there's, and we have Australians saying, oh, originalism is really better in Australia. That's the place where it ought to.
Not the latest thing the High Court said.
No. But no.
In a same-sex marriage case in December,
I'm not saying that.
They said originalism, which happens in other jurisdictions, is more distracting and unhelpful than in one.
I wasn't saying what the High Court said. There's an academic article saying that originalism makes more sense in Australia than in the United States. But the article talked about, of course, there's originalism in Turkey. It turns out there's originalism in Malaysia quite a bit that people don't know about because it's not translated into English. The paper was about originalism in Malaysia and originalism in Singapore. And then you've got some sort of strange things where I'm not sure what to say about certain things. So it turns out, so is proportionality analysis originalist? Well, it turns out that, and I hadn't known this, that the South African Constitution tells the judges to engage in proportionality analysis. So is that originalist or is that non-originalist? That begins to break, if we had a non-originalist provision in the Constitution, would that be originalist to follow it? So it turns out that there's quite a bit more originalism, and I think it may be that we've just scratched the surface of it, but maybe not.
I think Nathan, do you have a question? We have time for one more. Be brave.
For Barry, the only comment, Barry, was I wanted to sort of vote for both you and for Cy, which maybe tells something about me, but
You're a ticket splitter.
Maybe that's right. Both
I just think we agree, actually.
The plea for the document in the corner. Let's start talking about it again. My only point is I would like to suggest that a lot of originalist scholarship is substantive and not methodological.
I know.
And that, I think, is talking about the Constitution
Agreed.
a lot. And even if it's not a good way to do normative legal analysis, at a minimum, it contributes to the constitutional mythos that Garrick talked about. So, and I think those kinds of projects are, part and parcel with the originalist.
Yeah, I totally agree. And in fact, just because everybody might like some originalist context, the paper that Sarah Salo and I wrote that said all of this first was a response to Jack Balkin's book. So it's certainly not aimed at the right. It was just, it started as bemusement about exactly what the heck Jack was up to. But
well, I want to thank everyone for being so lively at the end of the conference. I want to thank my wonderful panelists. And I think the one thing that there's a consensus here is academics think judges need help. So.
I really enjoyed it. Thank you, Mike.
So I'd like to thank everyone for their participation, both the speakers and all of the audience who have been so patient. Maybe the kindest thing I could do is just say thank you and sit down. But I'm going to take the privilege of the director here just to offer a few comments on some things that have struck me, because I've thought this has been a very rich conversation, and I've been enlightened by it in a number of ways. It does seem to me that in a society where we make laws, let's say we make a law today, we pass a law, that seems to presuppose that we think that in the future, why would we do that if we didn't think that in the future, something's going to be different, it's going to govern the future? And it seems to me that if that's so, if that's why we pass a law today, that it must mean that the laws that were passed before us have some meaning, and so it seems to me that there is inevitably a kind of backward look in law that inheres in the nature of law, and therefore any kind of backward look calls into question the issue of history. Now, I think history can be, and I think the discussions here have made clear, that history doesn't necessarily mean one kind of history or another, that there is originalism, which is roughly trying to figure out what was meant by the lawgivers at the time that they handed down, whether that's meaning or intention or whatever. History also is how it's been taken over time, right? And it seems to me, I also think this may be in the nature of things, that this isn't just something that we happen to do. And one reason I think that is I think about another kind of interpretation that we engage in, which is scriptural interpretation, another enterprise in which there's a very old text and where we're interested in it not just as a matter of pleasure or curiosity, but because people who believe in it think that it has a normative pull on them today. And so how do we interpret the scripture? And I'm not going to do a comparative religion course here in 2 minutes, but they're Protestants and they're Catholics at least, And Protestants, by and large, to the extent they're in the Lutheran tradition, believe in sola scriptura, that is, it's the text, it's the beginning. And Catholics have traditionally looked to tradition as well, to the magisterium of the church, to the unfolding tradition of orthodoxy. And that makes me think that maybe these two modes aren't just things that we lawyers have come up with, but actually have something to do with the nature of interpreting old texts that are thought to be normative. Now, the good news in this is that it seems to me that in the last, say, 50 or 100 years, Protestants and Catholics have come together to a great extent, and that Protestants now talk about the tradition and look at interpretation over time, and Catholics are much more likely to pick up the Bible and read it in a way that would have been a little unorthodox 100 years ago. So maybe these kinds of history are going to come together. Now, one of the things that's been really interesting to me is the professional difference between historians and some lawyers, right? Lawyers are obviously divided, and I assume historians probably are too, but the overwhelming number of professional historians who engage in this debate express some kind of skepticism about whether the originalist enterprise, or maybe the historical enterprise altogether, makes very much sense. And I want to suggest that that the use of history in law is justified for legal reasons, not for historical reasons. That it has something to do with what is the grounding for judicial review, what is the meaning of law, what is the content of law. Those are all legal questions we might address in different ways, but they are not historical questions. And thus, I actually don't think historians, qua historians, have a lot to say to us about whether we should be making use of history. On the other hand, we've heard a lot of lawyers up here arguing about how to do it, and it seems to me that lawyers ought to pay a lot more attention to historians about how to do it, and maybe historians should pay more attention to lawyers about whether to do it. And one of the differences, maybe it's just the people who happen to have been gathered in this room over this particular conference, but one of the things I think I'm hearing from historians that rings quite true to me is that the way lawyers are doing history is a bit too focused upon linguistics and not enough focused upon historical and intellectual context. That for a historian looking at any of the contested provisions, I think one of the things we're hearing is that they don't pick up the dictionaries and they don't worry too much about linguistic conventions. Not that those things are completely irrelevant, but that's not where the meaning is usually going to be found. Where the meaning is going to be found is what were they arguing about? What was the point? Why was it necessary to add a privileges or immunities clause to the 14th Amendment? Why was it thought necessary to have a second amendment? And that involves looking a lot more at not just politics, but also the history of ideas. So you see, where did those concepts come from? Where do the ideas come from? And what's going on? And I do kind of think that the new originalism is losing sight of that in its preoccupation with meaning and intention and semantics. I mean semantics in a technical sense. And so I guess that may be my overall takeaway from the conference is that maybe I wish historians would stop telling us not to do it, but I wish we, the lawyers, would maybe pay a little bit more attention to the ways historians do it, so that when it is done, it makes more sense. So thank you.